You may be seated. Mr. O'Farrell, you may begin your closing remarks.
You please the court, counsel, ladies and gentlemen of the jury. Usually in the courtroom, we're able to position the podium near the jurors and I can sort of walk up and down and talk to you. And we're a few feet apart and I can communicate as effectively as I can. This makes me a little comfortable standing here at this distance. And of course, some of you are wearing masks and it's very difficult to communicate for me at least.
Mr. O'Farrell, you can move that podium.
I don't think I can move it in anything that's going to help me, Judge. Thanks.
Okay.
I appreciate that, Judge. I think I've seen enough of you to be aware that you've taken your oath very seriously here and that you're making every attempt to listen to the evidence and decide this case based on the evidence, which is what we are requesting. And what is your duty, really? So I want to talk about the evidence in this case. And of course, the evidence is very clear that Antonio Parham was shot to death on the early afternoon of January 27th of 2018. And the prosecutor's theory is that the person who did the shooting was Davion Thompson. And I asked you during the opening statement to pay careful attention to the evidence because it was the differences and the subtleties in the evidence that was going to show the difficulty in the prosecutor's theory in this case. Now, first of all, let's turn to the shooter himself. At this point, whoever it was. It's very clear. We've got evidence from the phones, which serves two purposes. And I say phones, there was the phone of Antonio, which he was holding in his hand, and the phone of the shooter, which we know from the evidence of the towers and Verizon records was moving toward the location where Antonio Parham was. And we know that there were text communications during that time frame between Antonio and the shooter. And it's very clear that the shooter didn't have a clear handle on exactly where Antonio was or was going to be. And they finally got it tracked down to 522 South Bond within minutes. And then Antonio got out of the car, he approached the vehicle, and there were shots fired, and Antonio was gunned down. The car backed up and sped away. Those were the actions of that shooter. And then we can still monitor through the phone records where the vehicle went from there. And it wound up being traced out to the location out in the apartment complex where Lisa Curtis lived. In addition, we get the circumstance that there's a Saginaw Township officer who hears the dispatch, Officer Glenn Hill, and he's going about his patrol business. And so he goes through the apartment complex, which is a big complex, many apartments, many vehicles, and he spots a vehicle that matches the description that's been given out over dispatch. A black Charger, chrome trim. And he sees it, and it's backed in to a parking spot. And so he gets out and he looks at it. He sees the tires have some evidence of wetness and debris consistent with having been driven on the wet pavement. It's a day that's just clearing. And he sees the engine is actually still warm, the hood area, indicating the car has been recently driven. And the car's backed in, and when he looks, there's no plate on the car. The plate's been removed. And when he looks for the VIN number, which is up on the dash, that's been obstructed. And as he's examining the car, he can detect the odor of marijuana. He can't remember anymore whether it was smoked or raw, but he remembers marijuana associated with that vehicle. And he calls it in. That happened at 1:18 in the afternoon. He got there within minutes and located that vehicle. And that took the shooter by surprise, because the shooter had been smart enough to take every step to avoid that vehicle being detected there in association with Lisa Curtis. He took the plate and he blocked the VIN number and he left. And they still had that phone, because the phone was then followed, and as Sergeant Kahn testified, it went towards Saginaw, towards the town area, and then stopped. The prosecutor indicates that it was Davion Thompson who was doing those things. And a great deal of that is in reliance on the testimony of Lisa Curtis. Even though the plate's been taken off the vehicle, Officer Hill goes and he talks to the manager, and that particular vehicle has been registered to Lisa Curtis, along with, she said she had another Charger there too. And so Sergeant Hill gives that information out, and when the city police hear that information, when Wenzel hears it, or it's conveyed to him when he gets on the scene, at some point he knows that Lisa Curtis's son had just been killed. And they determined that Lisa Curtis, on the 24th, the homicide's on the 27th, on the 24th, had sent them communication to the police indicating information about who the shooter was of her son, Brandon. And that information was pinpointing Antonio Parham as the shooter on the 24th. Those communications between the person to Lisa and her forwarding on to the police are in Exhibit 13. And you can examine that very carefully. Lisa communicates that's the information on the streets. And there's quotation mark around on the streets. As that, I'm letting you know who this is, who the streets are saying killed Brandon. He goes by Tone. He is the nephew of Keisha, who was a tenant at McGregor Manor apartment complex, but they have now moved. I've heard Brandon's friends say they are looking for him. Goes on to indicate that she and Tubbs are cut off. And she described her testimony when she testified before you. She wasn't sure if they were cut off or blocked or just couldn't get through. But at any rate, they couldn't communicate further. But she did indicate reference to the Bloomfield. She indicated to the police that Tubbs knew the address where he stayed. And she testified before you that when she made that statement earlier, what she meant was Bloomfield, that Tubbs knew Bloomfield. But Bloomfield isn't an address, it's a neighborhood. So if Tubbs knew the address as she had previously communicated, then that's inconsistent with the shooter who obviously didn't know the address. When Lisa gets called, prosecutor argues to you that she immediately says, well, Davion or Tubbs had her car. But you'll recall when I questioned Officer Wenzel, who had indicated that from his first phone conversation with her, when he was shown his testimony from the prior trial in this case a few months ago in March of 21, his words were, I think she said then that Davion had the car. I think she said that. And if you analyze the logic of this, what she could have known is when Davion picked up the car. We have some inconsistency there because the prosecutor argues that it was picked up from the apartments, but he also relies on the statement of Davion, where Davion said, and what he said was, when he asked to use the car, she said, why not? Everybody else is. That was her words, according to him in the statement. That's not challenged. Everybody else is. So you get into the issue of where was the car picked up and when. Now, there's no question that Davion had borrowed the car because he wanted to go to Jimmy John's and get his job interview in. That was discussed prior to everything. It's been in every statement. That's what Davion said. But he had this mono. And when he actually went to the interview, and there were a number of people there and he wasn't feeling very well, he didn't even bother to stick around. He probably had a pretty good inclination he wasn't going to get the job anyway. I don't know. But at any rate, he took the car back, and he took the car back to the same location, being where he had got it in the South End. What could indicate it there? Why would Lisa have her car on the South End? Well, we do know from Lisa that she was taking opioid medications, pills, 2, 3, 4 a day during that time. And that when she was taking them, she didn't have a prescription for them. We do know from the statement that she forwarded to the police, which was from Jamel, who she says was one of the friends of Brandon. In her statement, I've heard Brandon's friends say they are looking for him, referring to Tone. That statement from Jamel was, I paid 3 clucks. They all gave me same name. His Facebook name, Will Brother Beam Boy Tone. And you'll see attached with this communication, the front page, is that Facebook website of Antonio Parham. And there's, yes, I just found out too. It's the same communication. Which side of car was he found on? I need you to call me. That's from Jamel. That's the communication that Lisa sent on to the police on the 24th, 3 days prior to the homicide. Which side of the car was he found on? Does he mean Brandon? Is this a guy who would like to shoot Tone on the same side of the car that he shot Brandon on? You need to call me. That's all we have. Lisa also first told the police that Davion took her gun. It came up missing. She's asked, was he around? Yeah, he was in the house. She didn't actually accuse him of taking it in so many words, but she made it clear that the gun became missing and that he was the one that was there until she changed the story. Now, the story gets changed in the course of her being interviewed by Detective Giroux. This is after it's already very clear that her car and her gun are involved. That's why she's lying about the gun. And she is reluctant to testify. And this was brought out in her cross-examination before you folks. And Giroux says, well, let's cross that bridge when we get there. You know what I mean? It's not, I think of this way. You're not snitching, okay? This isn't snitching because you only know what you know. It's not like Tubbs said, hey, Ma, I killed him for you. You know what I mean? It's like it was your car that was used. That's all you're testifying to. It was your car that was used. Your son was killed to those facts. You know what I mean? Snitching is when you go buy a dime bag of weed, okay? You get caught by the police and you're like, hey, I got it from this guy who gets it from this guy. And man, he's got a whole lot more. That's snitching. This isn't snitching. Then we get the story that's even suggested by Giroux. It's not like he said, hey, Ma, I did it. Now she makes up a story that he confessed to her right there in the kitchen of the father of both twins, Donald Pennywell, right there in the kitchen. And she describes to you how Donald is right there and Garland Davis, who had come over, is right there too. And this is a couple of days after the homicide. And she says, that's where Davion said, I did it. And they were right there and they had to hear it. And in the preliminary in the prior hearing in this case, when she was under oath, she said they were right there. They had to hear it. You've heard the prosecutor try to say, well, he did say that neither Donald Pennywell nor Garland came forward to support what she says, which is true. Statements were taken from both, and Mr. Pennywell testified in a prior trial under oath and never supported that statement having been made by Davion Thompson, which the prosecutor could be right, they just don't want to tell, or that the statement was never made. And when that one's not supported, we get a new one. This is from the report of Detective Jacobs. Reports a phone call from October 2020. And this is in preparation for a trial that had been scheduled in November, but couldn't go because of the COVID. But at that point, she changes it from anybody else being around to being when she's bringing Davion to the police station. Then he tells her that he did it. Don't say I had your car. And tells her what to say. Now, that helps because it explains some of the inconsistencies in her story before, which the prosecutor says is because she didn't want to come forward. This is the lady who on the 24th sent the police a communication from one of the friends of Brandon, Jamel, one of the friends who were looking for Tone. The story, his statement about paying 3 clucks to find out who it is. And it's Tone. And here's his Facebook. That's Jamel. So we had this story at that time. Then we get a final little variation in the testimony before you. And that is her claim that the messages that she sent from the 24th of January had in fact been sent earlier. But she's confronted with her testimony when she was under oath before, back in March of this year, that it was the 24th. And her statement that it was just printed on the 24th doesn't wash at all. When you look at Exhibit 13, you're going to see that it's communication of January 24th. And she did testify that she sent it all at once. There were no prior communications. Now, we don't have any witness then who corroborates Lisa Curtis. Davion goes with her to talk to the police. You know, the shooter had taken substantial steps to get away with this. They drove the car quickly to a specific location, the apartment complex where Lisa Curtis lived. They backed the car in. They took the plate off. They blocked the VIN number from being seen, and they left. Now, Davion comes into the police station voluntarily, and when Detective Jacobs sees him, he's shocked. Here the kid is that's coming in front of him voluntarily, wearing a blue mask. The information that they had was that the shooter was wearing a mask. So they questioned Davion. They give him his Miranda rights. He doesn't ask for a lawyer. He talks to him voluntarily. This is supposed to be the same person who took the steps to take the plate off the car, to block the VIN number, to try to get away, and now you show up and you waive your rights and talk to the police. And he tries to tell him the truth. He's not feeling well. You've seen the video. But he admitted that he had the car. Yeah, I had Lisa's car. She told me that that car's been used in the shooting. She told me I should come and talk to you too. She brought me here. I had the car. And I used it the same thing. I used it. I wanted to go to an interview. I said, can I borrow the car? And then he tells what really happened. He got it because, hey, everybody else is using it. He took it back to where it was. The keys were in it. A club car is going to have access when it's going to be used. After this thing was all over and it was searched by the detective, that car, did it go back to the owner? The owner was Lisa Curtis. Did she have the keys for it? Did she even still have the plate? Further, Davion says, I knew Tone. Yeah, the guy who got killed. Yeah, I did know him. I last saw him, I think it was probably in September of last year. I saw him at the Marathon station over on Court Street. And then there was some communication. He hit me up, I think it was the 15th and 17th or 15th or 17th. I'm pretty good with dates. And the prosecutor says, aha, he's lying. This makes him a murderer. But a little bit later on, as he explains why he didn't actually go to smoke marijuana, which it's clear in the exchange between the 21st and 22nd, that's what was being discussed about hooking up and smoking a joint or two. And it never happened. But what Davion does say is, I was already feeling sick. That's in there. You heard that this morning and you heard it originally. I was already sick. We got the hospital records as far as the sickness of Davion Thompson, supplied them to the prosecutor's office. And by stipulation, we have admitted those for you. They're Exhibit 46 in this case. And the prosecutor has this theory that Davion had this plan worked out where if he went to the hospital, he could get masks, plus it would give him an excuse. Hey, I was sick. This is at 11 p.m. on the 25th, and he's there until about 2:28 in the morning on the 26th, through the night. And he's tested. The history, and you can read, it's in there. He thought he had strep throat. He was negative for strep throat. But as they examined with the symptoms and complaints that he had about his fatigue and the cough and the other issues, they checked him also for mono, and sure enough, he was positive for mono. That's what he had. And he had the underlying asthma condition. That's right in the reports and conclusions of the doctor. And as far as making things up, no, he had positive findings too, including enlarged tonsils that had pus, infection. That's not something you make up. You saw Davion when he's trying to be interviewed with the police, trying to cooperate, coughing, hacking. And the police say, we can't hardly hear you with that mask on, but keep it on. We don't want to catch this. And they say, well, he said he communicated by Facebook on the 15th or 17th. And it was actually by phone, text. Those lies prove he's a murderer. Those private lies, that discrepancy proves he may have been mistaken. You heard Sergeant Kahn talk about the way people use their phones, and they use Instagram, or they use Facebook, or they use text. It all kind of runs together. What is important is Davion admitted that he was in communication with Tone about getting some marijuana and smoking it. And if he was wrong about it being the 15th or 16th, what he did say, what really struck more than the date was, I was already feeling sick, which the history says that started about Sunday. He's in there on a Thursday, on the 25th, the night, the Sunday. It's right in the time frame of the 21st and 22nd. While his dates were wrong, he acknowledged exactly what he and Tone were communicating about on the 21st and 22nd. Then he thought he lost his phone. Lisa was having trouble getting a hold of him. She finally got a hold of him on Facebook. And he says, I think I lost my phone at the hospital. Well, folks, when you lose something, you don't know where you lost it, or you wouldn't have lost it. He thought he lost the phone at the hospital because he didn't have it. But as it turned out, he didn't lose it. It was in the possession of the shooter. One of Brandon's friends who's looking for Tone Davion also gives truthful information. I ask him right away for his phone number, and he gives them the phone number, 443-0029. That's his phone. They ask him where he lives. He gives them the Washington address, which they then use to get a search warrant to go to his house, which they execute. And they find in his house his driver's license. They find blue masks. Aha, Detective Jacobs locates the mask in the same basement area where the driver's license is. You want to know why? Because they're Davion's masks. That's what he got at the hospital. And the prosecutor says, well, he didn't have to have a mask. This was pre-COVID. But he had the underlying asthma. The doctor said, first of all, she couldn't admit him because he didn't meet the criteria for admission. It has to be life-threatening or serious. He didn't meet that criteria, so he was discharged after emergency treatment. The insurance would have paid for his admission. When you look at the grades, of hospital care, you have people who are in critical condition, which is life-threatening. They're in serious condition. They're in stable condition. And then they get released. She says, I didn't prescribe masks for him, but he could have gotten them from, if he asked anybody for one, he could have gotten a mask. Now he's got this asthma, and the prosecutor tells you, well, he's making all this up. But now we have the 3 exhibits from back in 2014. We had I think I requested, we were right at lunchtime, and I requested to have you be able to look at those because the date was so small on them. I wanted the details to be there. Those are from 20 and 14. 3 different dates, one in June, one in July, and one in October, all with blue masks. And the prosecutor argues to you, well, you put this one under the light and it almost looks white if you turn it this way, but when you turn it back this way, then you can see it's blue. So he wears a blue mask to the police station to be interviewed. He's got blue masks in his basement bedroom where he stays. He's wearing blue masks back in 2014. And he wears a mask when he gets sick. He thought he had strep throat. He was sick. That young man that you saw on the video was sick. He was sick enough the cops didn't want to get around him. Keep your mask on. The police find something else that gets them all excited at his house. And that's some weapon, bullet, 40 cal, Smith & Wesson. Holy crap. We can tie this in to the shooting because the evidence found at the crime scene, in the clothing of Antonio, and in the floorboard area of the Dodge were all fired from the same gun. And this is where Sergeant Russo gives some very important testimony in this case. Because he says that when you match the casings, the firing pin evidence, that discloses that all of those casings were fired from the same weapon. When you match the bullets, partials, the rifling shows that those were all fired from the same weapon. Now, you can't necessarily say that the casings and the bullets were totally the same, but common sense tells you when you find bullets and casings in the same area that match, it would have come from the same gun, which is true. I have no argument with that. We've got the single shooter here, one of Brandon's friends. But lo and behold, the Michigan State Police sergeant who examines firearm evidence concludes 100% clear that that evidence found on Washington couldn't have come from the same gun. And the prosecutor comes up with something that's not even any evidence that, well, it had to be a gun of Garland Davis, came from a different area. That shows the problems in the case and that the evidence actually points away. Like they had the wrong gun on Washington Street, they've got the wrong man as the shooter. And what's more important about that? Everything's a blue mask involving Davion Thompson. And yet, we had an individual who is conscientious enough to call 911 when she sees some unusual and hears some unusual things on the afternoon of January 27th. She doesn't know who or what. She has no reason to lie. In fact, as she testified, she was trying to help the police. She picks up and calls 911 to try to assist. She comes to court to testify, to tell the truth, to assist. And she saw that vehicle doing the things that we would expect, driving slowly as the shooter was tracking down Antonio. She sees that car after she hears shots. 5, maybe a few more, maybe a few less, but truthfully describing the shots and then seeing the same car tearing down Porter Street. At which point, she gets a glimpse of the driver, which she conveys to the police. He's wearing a mask. And she comes in and she testifies under oath, while she's wearing a blue mask. This is back when we had to wear the masks because of the COVID. And she says, it was like this, but it was yellow. And I said, are you sure? And she said, yes. The prosecutor then confuses her. Prosecutor says, well, it's been a long time. Are you sure after all this time? And you could see the look on her face. This is no fantasy. This is a young lady who's come forward to tell the truth, and she's confused. Could you be wrong? Are you 100% sure? This is the prosecutor. What am I doing wrong? She says, no, I'm not 100%. But what she saw was a yellow mask. And that's what the shooter was wearing. And it's positive evidence that shows that the shooter was not Davion Thompson. We don't have to prove who it was. Was it Jamel? Was it one of the other friends of Brandon that was looking for Tone? Was it a group? Who was it? Prosecutor says, well, other evidence shows it was Davion. The DNA evidence shows it was Davion because there's a 1 with 23 zeros that says that his DNA was one of the contributors on a gun site that was found at the scene. Prosecutor says that that's evidence that Davion handled the site. The testimony of Graham was read, or you viewed it. It was from the prior trial. And I'm reading from the written portion of that, so I know I get it right. I asked the question. So with all your expertise and experience, and as hard as you've worked on this case, you can't tell the jury whether Mr. Thompson ever touched that gun sight, can you? Answer, no. I can only testify that the DNA is consistent with his being on there, but not how it got there. Thank you, Judge. I have no further questions. Mr. Fedoruk, nothing further. The conclusions that the prosecutor is asking you to draw couldn't have been drawn by the witness. They're improper, and there's no evidence to support it. This goes on when the prosecutor indicates that the phone records conclusively confirm that Davion was using the phone on the 27th. Well, you heard the testimony of Sergeant Kahn. One issue in this case is these TLO information you get from the data company, because it confirmed, it was consistent with and confirmed that Brandon Pennywell was the user of the phone during the time that he had it. He was killed in November of 2017, but he had given the phone to Davion months before. But the TLO doesn't show Davion as the user of that phone. It doesn't. It contradicts it. It's not definitive because the phone may not have been used that much, according to the sergeant. But his usage for the time frame from the end of December till when the phone shut off showed heavy usage, but not a single user, not Davion or anybody. There were multiple users for that phone. That's why it's not conclusive. The phone is in a house. We have phone tower information that says the same tower had a great number of calls off that phone. One sector of that particular tower had more than the others. That those phone calls came around the clock. Certainly indicating that others were using it. There's no home number in that house. People can have more than one phone. People who want to communicate with me routinely give me 2, 3 numbers to reach them. And all I get are recordings. The actual evidence doesn't support the conclusion as to who had that phone on the 27th. Who was the shooter? This isn't Perry Mason. This isn't a courtroom. If I were Perry Mason, somebody in the back of the courtroom, I could turn around right now and point to them and they jump up and finally admit that they did it. There's not even anybody in this room. I can't prove who did it. I have strong suspicions concerning Jamel. I have a very sick young man. When this was communicated on the 24th, he's in the emergency room on the 25th. He's still sick when he's talking to the police on the 30th. He's the guy who tracked down Tone on the 27th, drove to the location, drove over to Lisa's house, dropped the car off, took the plate, covered up the VIN number, and left the scene. Or was it somebody else? He's the guy who's dumb enough to go to the police station with Lisa wearing a blue mask because he's sick and is confronted. We have all this evidence. You saw the detective. All this evidence says you're the one. We know you did it. We have witnesses who saw the mask. They saw you do it. You got to help yourself out. Don't let us prove you're a monster. This was because you were just acting because your buddy had been killed. Give us something to work with. You know, that interview started at the time we were taking it here about 1:54. And about 2:35 was when I made my note, when they switched tactics and they began to confront Davion and accuse him of lying and saying, we got all this evidence. The problem with all this evidence is it's contradicted by the real evidence in the case. So I'm not going to prove who actually did it here. But what is clear from the evidence and the lack of evidence in this case, I guess one more thing I have to mention. This business about fingerprints and DNA on the car. You know, prosecutor says, well, we got the information on the DNA on the gun site. They didn't get that till 2019, after the first trial. And they never got the evidence from the car because the detective told you, we already knew Davion was in it. That's not the point, obviously. If someone breaks into my house, they're going to get my fingerprints, but I want them to get the stuff from the guy who broke into my house. Do they not check? Would they not check the door handle, or if they broke in the window, the locations? This was a car that was backed up at least twice that we know of. Backed up to get out of the driveway at the shooting, and then backed into the parking spot at Lisa's place. You don't drive that distance and drive faster than the speed limit as you're speeding away without touching the steering wheel, without touching the shifter, without getting in and getting out. You may not be the primary contributor, but you could be a contributor. And if they get your identity and compare it to your DNA, there could be an identification. None of that was even attempted. The contradictory evidence, the lack of evidence, leads to only one conclusion in this case. There is reasonable doubt that the man who's charged was the friend of Brandon who killed Tone. I can't prove to you who, but there's reasonable doubt about this young man based upon all of the circumstances. This is the last opportunity that I'll have to speak with you. Mr. Fedoruk can come back and say that everything I've said is a crock. And I'm sure when I sit down, I'm going to think of something else I wish I would have said. It's never happened to me that I haven't thought of that. But you folks have been paying attention. You folks have sworn to follow the law and apply the law in this case where it takes you. And when you follow the instructions of Judge Jackson, the verdict in this case is that it hasn't been proven. And Davion must be found not guilty. Thank you, Judge.
Rebuttal remarks, Mr. Fedori.
Yes, Your Honor. All right, so the bottom line is somebody other than Davion Thompson killed Antonio Parham. And I guess Lisa Curtis was somehow in on that. Mr. O'Farrell doesn't know who that other person is. Let's explore that a little bit. All right, so what do we have that the killer needs to have access to commit this crime? So the killer was driving a black Dodge Charger. Lisa Curtis's black Dodge Charger. The killer had Lisa Curtis's .40 caliber Smith & Wesson handgun. The killer had Brandon Pennywell's cell phone. And the killer was wearing a surgical mask in 2018, pre-pandemic. Let's just start with the mask. All right. So there's some photos you saw. Mr. O'Farrell points out correctly, those are from 2014, show the defendant wearing one of these surgical masks. So the defendant, for some reason, liked to wear these surgical masks. Again, his doctor testified there was no benefit to him wearing the mask. Be it asthma, be it mono, there was no benefit. There was no COVID in 2018. There was no COVID in 2014. Why he wore them, we don't know. Why he wore it on January the 27th, 2018, when he killed Antonio Parham. We know that he used it to conceal his face. But let's entertain this, okay? Let's entertain this. So someone, the real killer, knew that the defendant wears these masks. Okay, all right. So it's someone who knows Davion Thompson. All right. Okay, we got that. All right, now let's move on to the phone. So it's Brandon Pennywell's phone. Okay, so someone got a hold of this phone. Now, counsel concedes that on January 21st and January 22nd, the defendant had that phone, which those text messages show, which Detective Kahn's testimony shows. Okay, so the defendant had it on that date. And that corroborates Lisa Curtis, that the defendant got the phone from Brandon Pennywell. All right, so somehow this phone gets out of the hands of the person who's using it, Davion Thompson, and gets in the hands of the real killer. Now, this person needs to be making the same phone calls that are being made on this phone through the course of December 1st, 2017 to January 28th, 2018. He needs to be making the same calls as Davion. You saw the location data. the location that this phone is most commonly at is the phone is pinging off of the closest cell tower to the defendant's residence. So this mystery guy has to be living right near the defendant, maybe with the defendant. Okay, now, let's think about this for a while. All right, so it gets a little confusing, so just give me a second here. So let's entertain that the defendant lost the phone. But here's where I'm confused, because you lost the phone at the hospital, but then Lisa Curtis is in on it with the real killer to get the real killer the phone. So wait, is Lisa Curtis getting the phone from the defendant and then giving it to the real killer? No, because you lost it at the hospital. Sorry, that's beyond my level of thinking, especially when we're going beyond lunch here. I don't get it. I'm sorry. Now, okay, well, let's just move past that. All right, now that same person who got the phone, somehow, that person has to be able to shut off the phone. Okay, so January 27th, the real killer shuts off the phone. So this is someone who knows the password to the phone, some information that Davion Thompson knows to shut off the phone. So, I mean, Lisa Curtis wasn't using the phone. It was her son's phone. And then it goes to Davion Thompson. Davion Thompson's using the phone. So it goes to someone else. So I don't know, I guess Garland Davis is living with the defendant.
And I have to raise an objection as far as going beyond the evidence in terms of password. There was no evidence of that. The only thing that was needed was the account information.
Mr. O'Farrell, this is closing argument. The jury will use their collective memory for what the evidence actually was.
Thank you, Judge.
Proceed.
Okay, account information. So that person needed to have the account information. Maybe it's a password, maybe it's some other information. Okay, all right, well, maybe Garland, because he's living with the defendant. All right, let's go down this route. Maybe we'll figure out something for us here. All right. Well, I know that there's no evidence he was at the hospital. I mean, do we know that he would have gone to the hospital with the defendant and found the phone? But then, wait, what? If Garland found the phone, why wouldn't the defendant know? They're good friends. They live together. No, that doesn't work. Okay. Oh, well, now I got it. So we're back to the conspiracy that Lisa Curtis is involved in with whoever the killer is. Okay.
Your Honor, for the record, I have to renew my objection. The testimony was that the account information had not been changed since the phone was opened up.
Mr. O'Farrell, you understand I instruct the jury that arguments of the counsel are not evidence and they're disregard them and use their own collective memory. So that's what the instruction will be to the jury. What counsel says is not evidence. And they're to use their memory. This is closing argument. Over your objection, proceed.
All right. So we got Lisa Curtis and Garland Davis are in on something. All right, well, let's see. I got nothing else with the phone. All right, let's move on. Okay, the charger. So, all right, let's believe the defendant. Okay. So he left the car January 22nd at some parking lot on the south side. All right. And he left the keys in it. Man, now anybody could have picked the car up. Well, Mr. O'Farrell was talking about something about a cluck car and clucks and I don't know, chickens. I don't know. I don't know if he's saying that somebody involved with Miss Curtis taking opioids, the car, Garland Davis. Now I'm really mixed up. All right, let's move on. All right, so now the gun. So Lisa Curtis had to give the gun to somebody other than the defendant. That person got a laser sight that fit the gun. Now, the laser sight has DNA on it. There was an analysis of the DNA. And what was that number again? 0 or 1.0 octillion, 27 zeros. It's pretty compelling that it's very consistent with the defendant's DNA being on it. All right, well, Mr. O'Farrell did enlighten us about secondary transfer. He did remind us about the testimony from Ms. Graham about secondary transfer. Okay, let's explore that a little bit. So again, we're talking about framing Davion Thompson. So someone who had access to his clothing, to wipe his clothing on the laser sight. Is that what happened? Okay, Garland Davis has access to the defendant's clothing because they live in the same house. Okay, I got it. Garland Davis on a laser sight to get his DNA on it. Let me ask you this. So the gun was used to kill Antonio Parham. Why didn't he just leave the gun at the scene? Wipe the gun with Davion Thompson's clothing. Get his DNA all over that gun, and then you got him. Because then Detective Jacobs here, he's got the gun to analyze for DNA, and the defendant's DNA is all over it. Case closed. All right, let's look at this a little bit deeper now. Let's look at motive. Okay, so we got a bunch of people here who aren't happy with Antonio Parham because we got rumors on the street that Antonio Parham is the person who killed Lisa Curtis's son, Brandon. We got somebody named Jamal, maybe Garland Davis, Donald Pennywell, Brandon's dad. So you got all these people that aren't real happy. I guess the one thing is they're all friends. They're all friends with the defendant. I mean, let's go back to Garland Davis. He's a good friend with the defendant. What reason would Garland Davis want to kill Parham and then pin it on Thompson? So you're going to get revenge for Brandon's murder by getting Thompson with the finger pointed at him for committing it? Ladies and gentlemen, this is asinine. Lisa Curtis had absolutely no reason to tell the detectives that Davion Thompson admitted to killing Antonio Parham. She didn't have to tell him that. All she had to tell him was, oh, I gave him the gun, I gave him the car, and that's it. That's all she needs to say. Why would someone threaten her? No, you need to tell them that it was Davion because we need to get this pinned on Davion. They already had Davion as the suspect. Garland Davis wasn't the suspect. She didn't need to do that. I mean, why would she tell them that? She told the detectives that the defendant admitted to the killing because the defendant admitted to the killing. You know, I don't want to waste your time and go through all these points that defendant made, but honestly, they're just ridiculous. So DNA, counsel saying that DNA evidence, DNA analysis done in 2000, when was it? 2019 isn't good for 2018. No, you heard testimony from Ms. Graham. It doesn't matter. They could have sent it in yesterday. They still could have analyzed it. That the phone records showed around the clock activity. And so this supported that more than one person was using the phone. That's not what Detective Kahn testified. He gave the example of January 26th. From 12 a.m. to 10 a.m., there was no calls made on that phone. That's completely consistent with the defendant going to the hospital, getting treated, coming home, and going to bed, getting up at 10 a.m., making a call. No one else used the phone until then. The DNA evidence analysis is consistent with the defendant handling the site and the gun because of all the other evidence. And I asked that question to Ms. Graham. And she said affirmatively, yes, you look at everything. You look at evidence that corroborates the analysis to make that conclusion, whether the defendant's DNA was on it, whether the defendant handled it, or whether it was secondary transfer. There's no evidence of secondary transfer here. The evidence points conclusively to the fact that the defendant handled that laser sight, fired that gun, and he killed Parnell. I never accused Ms. Ziem of lying. Nobody did. The mask might have been yellow. I told you that. I pointed out the fact that she could have observed the color yellow coming from that mask because of the light, and you saw how that's a possibility. So maybe it was yellow. Maybe it looked yellow to her. Maybe it was a blue mask that looked yellow. Maybe it was a yellow mask. Maybe the defendant, when he went to the hospital 2 days earlier, maybe he got a yellow mask to throw people off. That's also a possibility. I'm not saying Ms. Ziem was lying. Mr. O'Farrell wasn't the doctor testifying. Ms. Bishop was the doctor who testified in this case. And she testified there was no medical benefit to the defendant wearing a mask. That was her testimony. That was the evidence. Mr. O'Farrell said that the defendant tries to tell the truth in the interview. I'll just stop right there. It wasn't in evidence what Donald Pennywell said about what the defendant said when Ms. Curtis and Mr. Pennywell and Garland were there when the defendant confessed. It's not in evidence. The testimony was clear. Pennywell, Garland, Pennywell is very close to the defendant. Garland, very close to the defendant. Defendant's statement that Lisa said everyone else uses the car, why don't you use it? Everything the defendant said in that interview is questionable and has no credibility. behind it. So I'm just going to stop there. The evidence is clear once again, okay? There's absolutely no foundation, no basis to any argument that there is some kind of setup here, that there is some kind of other killer. It's just asinine. The standard, again, is beyond a reasonable doubt. And that's a reasonable doubt. And there's absolutely no reasonable doubt here. There isn't even a doubt. Now, in closing, I recall, or I may be recalling incorrectly, but I believe that I've referred to the victim in this case as Antonio Park. And that's a mischaracterization on my part because there's more than one victim here. Because you heard from one of the victims, Brenda Long. She's got a daughter. She's got a daughter who never met her father. Mr. Parham had a family. It wasn't the defendant's right to take Antonio's life. It wasn't the defendant's right to take Antonio from his daughter, from Brenda, from his family. Whatever he heard on the streets, that was not his right. This was a brutal killing, inexcusable. And it was Davion Thompson who committed this. Again, find him guilty.
Members of the jury, the evidence and argument in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember, you've taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that you may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually. You should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as a law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way to decide the case. The person accused of a crime is presumed to be innocent. This means you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you're satisfied by a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find the prosecutor has not proven every element beyond a reasonable doubt, you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt, according to the evidence or lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a carefully considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence. You must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements and arguments are not evidence. They only meant to help you understand the evidence and each side's legal theories. You shall only accept things the lawyer said that are properly supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You're the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence. But you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based on the evidence admitted during this trial. This case has been tried before, and during this trial, you've heard some references to prior trials. Sometimes the case must be retried before a new jury. You should not pay any attention to the fact that this is not the first trial. Your verdict must be based on the evidence admitted in this trial. You must decide the facts only from what you yourself have heard and seen in court during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but I may help you think about these questions. A, was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? B, did the witness seem to have a good memory? C, how did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? D, does the witness's age and maturity affect how you judge his or her testimony? E, does the witness have any bias, prejudice, or personal interest in how this case is decided? F, have there been any promises, threats, suggestions, or other influences that affected how the witness testified? G, in general, does the witness have any special reason to tell the truth or any special reason to lie? H, all in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought, they saw, or remembered. It's also a good idea to think about which testimony agrees best with the other evidence. However, you may conclude that a witness deliberately lied about something that is important how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things, but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prior testimony of Brittany Zium and Nicole Graham was played during this trial because they are not available. This testimony was taken under oath at an earlier hearing. You should consider this testimony the same way you consider any other testimony you've heard in court. The prosecution has introduced evidence of statements it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant didn't make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made, and about all the evidence in the case. You may consider the statement in deciding the facts of this case. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, if you see a person coming from outside wearing a raincoat covered with small drops of water, that will be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You've heard evidence that before the trial, a witness or witnesses made statements that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial that was not under oath, only help you decide how believable the witness's testimony was when testifying here in court. If the earlier statements were made under oath, or if the witness testified during the trial that the earlier statement were true, then you may also consider the earlier statements as evidence of the truth of whatever the witness said in the earlier statements when determining the facts of this case. You may consider whether the defendant had a reason to commit the alleged crimes, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor doesn't have to prove that the defendant had a reason to commit the alleged crimes. He only has to show that the defendant actually committed the crimes and that he meant to do so. The defendant's intent may be proved by what he said, what he did, how he did it, or any other facts or circumstances in evidence. You've heard that a lawyer or a lawyer's representative talked to one of the witnesses. There's nothing wrong with this. A lawyer or a lawyer's representative may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You've heard testimony from 5 witnesses, namely Dr. Kanu Varani, who was giving his opinion as an expert in the field of forensic pathology, Dr. Caitlin Bishop, who's giving you her opinion as an expert in the field of emergency medicine, Nicole Graham, who is giving her opinion as an expert in forensic DNA analysis, Grell Rousseau has given his opinion as an expert in the field of firearm and tool mark identification and distance determination, and Randy Kahn, who's giving his opinion in the field of cell phone technology, cell phone records and analysis, and mapping and plotting. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts the expert gave for the opinion and whether those facts are true. You should also think about the expert's qualifications and whether the expert's opinion makes sense when you think about the other evidence in the case. You've heard testimony from witnesses who are police officers. This testimony is to be judged by the same standard you use to evaluate the testimony of any other witness. In count 1, the defendant is charged with open murder. Under this count, you should first consider the crime of first-degree premeditated murder. To prove this charge, the prosecutor must prove each of these following elements beyond a reasonable doubt. First, that the defendant caused the death of Antonio Parham. That is, that Antonio Parham died as a result of being shot by the defendant. Second, that the defendant intended to kill Antonio Parham. Third, that this intent to kill was premeditated. That is, thought out beforehand. Fourth, that the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about it and chose his actions before he did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of this case. The killing cannot be the result of a sudden impulse without thought or reflection. Under count 1, you may also consider the lesser charge of second-degree murder. To prove this charge, a prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Antonio Parham. That is, that Antonio Parham died as a result of being shot by the defendant. Second, that the defendant had one of these 3 states of mind. He intended to kill, or intended to do great bodily harm to Antonio Parham, or knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. You may infer that the defendant intended to kill if he used a dangerous weapon in a way that was likely to cause death. Likewise, you may infer that the defendant intended the usual results to follow from the use of a dangerous weapon. A gun is a dangerous weapon. Premeditation and deliberation may be inferred from any actions of the defendant, which show planning, or from any other circumstances surrounding the killing. The prosecutor need not prove a motive for the killing, but you may consider the evidence of motive in deciding whether there was premeditation and deliberation. Motive by itself does not prove premeditation and deliberation. In count 3, the defendant is charged with the crime of going armed with a dangerous weapon with unlawful intent. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant went armed with a pistol. Second, at that time, the defendant intended to use this weapon unlawfully against someone else. In count 2 and count 4, the defendant is also charged with a separate crime of possessing a firearm at the time he committed another crime. This crime is also known as felony firearm. To prove these charges, the prosecutor must prove each of these following elements beyond a reasonable doubt. First, as to count 2, that the defendant committed the crime of first-degree premeditated murder or second-degree murder. As to count 4, that the defendant committed the crime of going armed with a dangerous weapon with unlawful intent. These underlying crimes have been previously defined for you in the other instructions. It is not necessary, however, that the defendant be convicted of the underlying crime. Second, that at the time the defendant committed the crime, he knowingly carried or possessed a firearm. A pistol is a firearm. Possession does not necessarily mean ownership. Possession means that either the person has actual physical control of the thing, as I do the pen I'm now holding, or the person knows the location of the firearm and has reasonable access to it. Possession may be sole, where one person alone possesses the firearm. Possession may be joint, where 2 or more people share possession. In count 5, the defendant is charged with the crime of carrying a pistol in a vehicle. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that a pistol was in the vehicle that the defendant was in. Second, that the defendant knew the pistol was there. Third, that the defendant took part in carrying or keeping the pistol in the vehicle. The prosecutor must also prove beyond a reasonable doubt that the crimes occurred on or about January 27, 2018 within Saginaw County. When you go to the jury room, you'll be provided with a written copy of the final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like way, and that everyone has a fair chance to be heard. During the deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it's necessary that each of you agrees on that verdict. In the jury room, you discuss the case among yourselves, but ultimately, each of you have to just make up your own mind. Any verdict must represent the individual considered judgment of each juror. It's your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide that you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. Under count 1, there are 2 different crimes that you may consider. When you discuss count 1, you must consider the crime of first-degree premeditated murder first. If you all agree on that the defendant is guilty of that crime, you may stop your discussions and return your verdict on count 1. If you believe that the defendant is not guilty of first-degree premeditated murder, or if you cannot agree upon that crime, you should consider the less serious crime of second-degree murder. You decide how long to spend on first-degree premeditated murder before discussing second-degree murder. You can go back to first-degree murder after discussing second-degree murder if you want to. If you have any questions about the jury instructions before you begin deliberations, or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to my law clerk. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to my law clerk. It's not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, You may take your notes and full instructions. If you want to look at any or all of the exhibits that have been admitted, just ask for them. When you go to the jury room, you'll be given a typewritten copy of the instructions you've just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. The defendant is charged with 5 counts. These are separate crimes, and the prosecutor is charging that the defendant committed all of them. You must consider each crime separately in light of all the evidence in the case. You may find the defendant guilty of all or any of these crimes, guilty of a less serious crime, or not guilty. I've also prepared a verdict form listing the possible verdicts for you. Count 1 indicates a charge of open murder. Your possible verdicts are not guilty, guilty of first-degree premeditated murder, guilty of second-degree murder. Once you reach a verdict on this count, your foreperson will sign and date the verdict form. Count 2 charges felony firearm, underlying felony, first-degree premeditated murder, or second-degree murder. Your possible verdicts are not guilty or guilty of felony firearm. Once again, once you reach a verdict, your foreperson will sign and date the verdict form. Count 3 charges the defendant going with a dangerous weapon with unlawful intent. Your possible verdicts are not guilty, guilty of going armed with a dangerous weapon with unlawful intent. Once again, your foreperson will sign and date the verdict form. Count 4 charges the defendant with felony firearm, underlying felony, going armed with a dangerous weapon with unlawful intent. Your possible verdicts are not guilty or guilty of felony firearm. Your foreperson will once again sign and date the verdict form. Count 5 charges the defendant with carrying a pistol in a vehicle. Your possible verdicts are not guilty or guilty of carrying a pistol in a vehicle. Once again, your foreperson will sign and date the verdict form as to each of these counts. I'd like to see counsel at the bench, please. Ladies and gentlemen, that concludes formal instructions, and at this time, we will reduce the number of jurors who will decide this case. One of you will be excused by random lot. And if your name is called, I still would like you to just be seated at the time. Okay, Ms. Waters, even though you've been excused at this time, I would still ask you not to discuss the case with anyone, or listen to any news reports or articles about this case, because as an alternate, that's the case with the other jurors if that becomes necessary, okay? I will now ask you all to stand and swear to be affirmed. Ms. Waters, you can stand also. You too, Ms. Waters.
Discharge by the court is true and that you will go solely on the evidence in the accordance with the instructions of the court, so help you God.
Now, Ms. Earl, to the law clerk, please.
You will not communicate with you will not be put in
Ladies and gentlemen, it's now about 5 minutes to 1. We're going to excuse you for lunch at this time. And once again, don't discuss the case among yourself, nor with anyone else. Have a pleasant lunch. We'll see you back here at 2 p.m. And I don't want you to begin deliberations until all the jurors are present at 2 p.m., all right? You can take your articles with you as well.
Everyone, please keep your notebooks with you. Ms. Waters as well.
Be seated. The record will reflect the jury is not present at this time, and after I've read instructions, I had counsel approach the bench for any additions, deletions, objections, or corrections. Mr. Fedoric, I believe you had none.
Correct, Your Honor.
Mr. O'Farrell, I believe you had none.
That's correct, Judge.
Anything else for the record, Mr. Fedoric?
No, Your Honor.
Mr. O'Farrell?